Welcome to the Tennessee Department of Education's overview of Title VI. My name is Chandrea Hersey, and I'm the Assistant General Counsel for Civil Rights in the Office of General Counsel at the Tennessee Department of Education.
Hello, my name is Natalie Perriman, and I'm a staff attorney for the Tennessee Department of Education's Office of General Counsel.
Hello, my name is Nikki Keene, and I'm a paralegal at the Tennessee Department of Education, Office of General Counsel.
This training is going to provide an overview of the Federal Civil Rights Law, Title VI, that prohibits discrimination and harassment based on race, color, and national origin.
So before we jump into the training, I just want to remind you guys of our strategic goals as seen here on the slide. These are our best for all standards, academics, student readiness, and educators. These are the things that we want to make sure we're focusing on in our everyday practices. Today's training will cover a general overview of Title VI, and it will also cover some additional considerations to be mindful of. First, we're going to begin with, again, a very basic overview of Title VI of the Civil Rights Act of 1964. Title VI is a federal provision that prohibits discrimination and harassment based on race, color, or national origin. When we use the term race, we're referring to a group of persons related by common descent or heredity, and this can include physical and non-physical traits of that group. When we use the word color, we're referring to skin tone, light tone versus dark tone, and everything in between. When we say national origin, we're referring to the country a person is from or where that person's ancestors were from. I want to remind you that the proposed rulemaking changes to the Title VI regulations are anticipated to come out sometime around August 2023. So under Title VI, there are federal obligations for districts that exist to make sure that students who are English language learners are equally protected. Schools, districts, and state education agencies must take affirmative steps to ensure that students with limited English proficiency can meaningfully participate in their educational programs and services. Under Title VI, again, there is a legal obligation to serve English learners. Additionally, schools must communicate information about programs, services, or activities to limited English proficient parents or guardians in a language they can understand. Under Title VI regulations, there are also obligations for schools and districts to make sure they are ensuring equal rights to public education for students, regardless of their immigration or citizenship status. Remember, students cannot be barred from enrolling in public schools at the elementary or secondary level on the basis of their own citizenship or immigration status or that of their parents or guardians. Remember, districts may not request information with the purpose or result of denying enrollment based on citizenship or immigration status. Next, I'm going to turn it over to Nikki to discuss discipline as well.
So under Title VI, school districts are prohibited from engaging in discriminatory discipline practices. So discussing what that means, discipline policies, practices, and procedures must comply with the non-discrimination requirements of Title VI. Under Title VI, school districts are prohibited from engaging in discriminatory discipline practices. So discussing what that means, discipline policies, practices, and procedures must comply with the non-discrimination requirements of Title VI. This means that schools may not engage in practices such as subjecting students of one race to more discipline or harsher discipline than students of other races. With regard to special education, policies, practices, and procedures must comply with the requirements of Title VI to prevent racially discriminatory decisions related to special education or related aids and services. So what this means is that schools may not engage in practices such as over-identifying students of a particular race for special education. Now we're going to discuss school districts' obligations under Title VI. So under Title VI, schools are obligated to enforce civil rights laws by instituting practices and procedures that prohibit discrimination and harassment on the basis of race, color, or national origin. And if such discrimination or harassment occurs, the school district must take prompt and effective steps reasonably calculated to end such conduct, prevent the conduct from reoccurring, eliminate any hostile environment, and remedy its effects as appropriate. So what this means is that if the school has knowledge of discrimination or harassment, they are obligated to take steps to address it and prevent their conduct from reoccurring. Please familiarize yourself with your district's anti-discrimination and harassment policies and reporting procedures. So going into some of the definitions that apply to Title VI. So under Title VI, discrimination is conduct that deprives a student of the benefit of an educational opportunity on the basis of race, color, or national origin. So discrimination essentially means that you're treating individuals differently or unequally as a result of their race, color, or national origin. Harassment under Title VI is defined as behavior that is directed at a student based on their race, color, or national origin that interferes with their academic performance or participation in a school's programs or activities, and that discrimination creates a hostile learning environment that a reasonable person would find threatening, intimidating, or hostile. So basically, harassment is defined as unwelcome conduct that is based on race, color, or national origin. And this can include written statements, verbal statements, or physical acts. Title VI defines retaliation as an adverse action against an individual for filing a complaint or participating in an investigation. So Title VI protects individuals from retaliation when they oppose any discriminatory practices or file a complaint or testify or participate in any aspect of a Title VI complaint. They are protected from retaliation under the law. Going into the federal harassment or federal definition of harassment, it is defined as conduct that is sufficiently severe, persistent, or pervasive, and it creates a hostile educational environment or interferes with or limits a student's ability to participate in or benefit from the services, activities, or opportunities offered by a school, and it involves their race, color, and national origin. I will go into some more detail about what severe, persistent, or pervasive means in the next slide. So under Title VI, severe is defined as extreme acts or actions that may include physical assault or severe threat of bodily harm. So this includes behavior that is intense or extreme or serious, or conduct that may cause emotional or psychological distress. Persistent means behavior that happens repeatedly. So this is behavior that is widespread or consistent over time. Even though a particular act may not be severe on its own, it could still have a cumulative effect that creates a hostile educational environment. And pervasive means it is unwelcome behavior that is found throughout the school environment. So this is behavior that affects the school climate and culture as a whole. Next, we're going to discuss types of harassment that apply under Title VI. So harassing conduct can take many forms. It can include verbal acts. It can include name calling, graphic written statements, or conduct that may be physically threatening, harmful, or humiliating. This includes slurs, jokes, or comments. It can include words that are written on a student's clothing. It can include words that are on the walls of a school or written in sheets of paper, for example. It could also include behavior that is threatening as well. So we must remember that harassment, it does not have to include an intent to harm. It does not have to be directed at a specific target, involve repeated incidents, or involve an imbalance of power.
So you just heard information about the requirements of Title VI and what is covered under Title VI. We also want to share some additional considerations for districts, just some additional things that districts should consider when they are implementing their policies and procedures that prohibit discrimination and harassment based on race, color, and national origin. So first, it's important to understand the difference between racial harassment and bullying. Remember, racial harassment is prohibited under Title VI, and bullying is more so addressed by our state level anti-bullying law. Calling racial harassment bullying or teasing, it can be offensive to students and families, as it may minimize the severity of the behavior. Districts want to be sure that they are appropriately labeling incidents of racial harassment. Also, you want to ensure that you are resolving these situations appropriately, because if not, then it could open your district up to legal risks. Remember that districts are obligated to remedy the effects of harassing conduct, and if a district is not addressing harassment correctly, then they may fail to meet their obligations under Title VI. It's important to understand the difference when it comes to coding and how information is going to be coded in a student management system or a student's discipline records. And also when it relates to issuing disciplinary consequences, ensuring that appropriate discipline is assigned to particular instances of conduct. And also in those follow-up conversations with parents and students, being clear about what the conduct was and how the district is addressing the conduct. The second thing that's important to remember is that Title VI applies outside of the classroom. Remember, the scope of federal civil rights laws includes all programs or activities that receive federal funds from the U.S. Department of Education, and that includes all program areas: academics, extracurricular, and athletics. Remember, this includes those on-campus activities, but also off-campus activities that may be sponsored by a school. Students are protected from discrimination and harassment from other students, but it's also important to remember that students are protected from discrimination and harassment from school district employees as well. That includes teachers, counselors, administrators, front office staff, just anyone who works in your buildings, and even third parties who may be hired by the district. So that will be your contractors, vendors, and even visitors. Another thing that school districts should remember as it relates to Title VI is that they should not let free speech or the First Amendment excuse harassment. Examples of when schools may restrict on-campus speech would include true threats of physical violence or harm, vulgar or lewd speech, or speech that creates a substantial disruption, or it is reasonable to assume that it will create a substantial disruption. If the speech takes place off campus or social media or on social media, then the district may be required to respond to that off-campus conduct if it could create a hostile environment or could cause a substantial disruption. And these can be really complicated issues, so we encourage you to always consult with your local board attorney as quickly as possible whenever these issues are reported. Also, as it relates to free speech and the First Amendment, it's important for schools to remember that students do not have an unfiltered right to free speech, and placing restrictions on disruptive student speech does not necessarily run afoul with the First Amendment. A school should not purport to use the First Amendment to skirt its responsibility to prevent responding to claims of harassment under any applicable civil rights law. And remember, always consult with your board attorney whenever there are concerns about student speech and any type of harassment. The last important thing to remember is that school districts should consider a school's climate and culture when addressing concerns of discrimination or harassment. When discrimination, bullying, or harassment is widespread and pervasive throughout a school, then issuing discipline or separating a few students, it may not be enough. Remember, you are obligated to address and remedy any concerns and to prevent their reoccurrence. Measuring a school's climate is a great way to determine any appropriate actions that may be needed, and then offering training or programming for students or changing reporting procedures are other great ways to address climate and culture concerns. Thank you for watching today's training. If you have any questions, feel free to reach out to any of us. Our contact information is here on the screen, and we are happy to answer any questions.